Today we cover Fernandez versus United States, a 6-3 decision authored by Justice Barrett, handed down May 28, 2026. The court ruled that a federal prisoner who wants to challenge whether his conviction was sound must go through the strict habeas corpus process. That's the formal legal route for attacking a final conviction, and cannot use the more flexible compassionate release statute as a shortcut. Justice Sotomayor, joined by Justice Kagan, concurred in the result. According to them, the majority got the reasoning completely wrong, and Justice Jackson dissented.
And the stakes here go well beyond one prisoner. This decision reshapes how thousands of federal prisoners can seek relief when they believe their convictions rested on shaky ground.
Before going further, here's your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com. All right, here's what you need to know.
Let's rewind to 2013 in federal court. The Southern District of New York. Prosecutors charge a man named Joe Fernandez with conspiracy to commit murder for hire and a firearms offense. The prosecution's theory: members of a drug ring paid Fernandez $40,000 to act as a backup shooter in the assassination of 2 gang members.
$40,000.
Right. And the story goes like this. The primary shooter's gun jammed, so Fernandez allegedly stepped in, fired 14 rounds, and killed both victims. The prosecution's key witness? Fernandez's own cousin, Patrick Darge, who testified against him at trial.
And Fernandez's defense was basically, Darge lied. He claimed Darge framed him to protect Darge's own brother, who Fernandez said was the actual second shooter.
The jury didn't buy it. They convicted Fernandez on both counts, and the trial judge, Judge Alvin Hellerstein in the Southern District of New York, sentenced Fernandez to 2 consecutive life terms. That's die-in-prison territory.
And Fernandez fought this every way he legally could. He raised what's called a Brady violation. That's a claim that prosecutors illegally withheld helpful evidence. Specifically, he argued the government should have disclosed that another alleged co-conspirator, a man named Luis Rivera, denied driving the getaway car. The judge reviewed the government's interview notes, found nothing relevant, but noted he felt troubled that prosecutors gave Rivera a lenient plea deal, a lesser narcotics charge with the murder counts dismissed.
And here's where things get interesting. Over the years, those doubts about Rivera never went away. At least not for Judge Hellerstein. In 2021, when the judge vacated Fernandez's firearms conviction on a completely separate legal ground, he speculated in writing that the government's generous deal with Rivera suggested the government knew something inconsistent with Darge's testimony. And he pointedly noted that if Fernandez's murder for hire life sentence were set aside, Fernandez would walk out immediately.
So the judge was basically sending a signal.
Fernandez took the hint. Within 2 weeks, he filed a motion for compassionate release. That's a legal mechanism Congress created that allows prisoners to seek early release for extraordinary and compelling reasons. He argued his potential innocence qualified. Judge Hellerstein granted it, reduced the sentence to time served, roughly 11 years, and said he harbored a certain disquiet about whether the jury's verdict was correct.
The Second Circuit reversed. Let's walk through how this got to the Supreme Court. So the Second Circuit reversed the district court and said, clearly, that challenges to the validity of a conviction simply cannot count as extraordinary and compelling reasons under the compassionate release statute. 7 other federal circuit courts agreed with that position. 2, the First Circuit and the Ninth Circuit, took the opposite view and said conviction-related concerns can factor in.
And that disagreement between the circuits got the Supreme Court's attention.
The Supreme Court took the case, heard argument on November 12th, 2025, and handed down the decision May 28th, 2026. So let's get to the legal question. What exactly did the court need to decide?
2 statutes sit at the center of this case. First, the Compassionate Release Statute, 18 U.S.C. Section 3582. It says a court may reduce the term of imprisonment if it finds that extraordinary and compelling reasons warrant such a reduction. No definition of extraordinary and compelling. Pretty broad language.
And second?
Second, 28 U.S.C. Section 2255, the habeas corpus statute for federal prisoners. Habeas corpus, which is Latin for "you shall have the body," basically means bring this prisoner before a court and justify why you're holding them. Section 2 2255 gives federal prisoners the formal route to attack their convictions, but it comes loaded with restrictions. 1-year deadline to file, generally only one shot at relief. Claims you already lost on direct appeal, you can't relitigate them. And you must show both cause and prejudice for issues you didn't raise during your trial.
So Fernandez lost under Section 2255, then turned around and tried to use the compassionate release statute to raise the same kinds of arguments. And the question for the court, can those arguments, essentially doubts about whether the conviction rested on reliable evidence, count as extraordinary and compelling reasons under the more lenient compassionate release law?
Let's walk through what the court said. Justice Barrett wrote for 6 justices. Roberts, Thomas, Alito, Gorsuch, and Kavanaugh joined. And the majority built its case on 2 pillars.
First, the anti-circumvention principle. The majority looked back at a pair of earlier Supreme Court decisions. First, Prizer versus Rodriguez. That's a 1973 case. State prisoners tried to use a civil rights statute, Section 1983, to challenge the loss of good time credits that would have shortened their sentences. The court said no. Congress designed the habeas statute specifically to handle challenges to the fact or length of confinement. That specific design overrides the broader civil rights statute. The majority called this the principle that claims close to the core of habeas corpus must travel through the habeas statute.
So Congress built a specific lane for those challenges, and prisoners have to stay in that lane.
Right. Then the majority pointed to Gonzalez versus Crosby, a 2005 case. Prisoners there tried to use a civil procedure rule, Rule 60B, which lets courts reopen final judgments to relitigate habeas claims they'd already lost. The court again said no, even though the rule's language said courts could reopen judgments for any reason. Using it to re-argue a habeas denial would circumvent the strict rules Congress wrote for habeas relief.
And the majority said Fernandez pulled the same move, just with a different statute. And here's where the majority made it personal. Fernandez admitted at oral argument that avoiding Section 2255's procedural requirements represented a benefit of his approach. In the majority's view, that's not a feature, it's a confession.
What's the second pillar?
The structure and purpose of Section 3582 itself. Barrett pointed to several things. First, the statute's official title, compassionate release, mercy, not legal error correction. Second, Congress gave special attention in the statute to terminally ill prisoners and elderly prisoners who served long sentences and posed no danger. Third, the Bureau of Prisons serves as the gatekeeper. Before the First Step Act in 2018, only the Bureau could even file a compassionate release motion. And even after 2018, prisoners must first present requests to the Bureau.
And the majority said, what does the Bureau of Prisons know about evaluating trial transcripts?
Nothing. The Bureau's expertise covers the daily lives of prisoners, health, safety, rehabilitation. The majority pointed out that even Fernandez conceded evaluating trial errors falls outside the Bureau's wheelhouse. And yet Fernandez wanted the Bureau to comb through witness testimony and Brady arguments. The majority said that makes no sense.
Did the majority engage with Fernandez's argument that he was seeking a different remedy than habeas? Just a sentence reduction, not vacatur of his conviction?
It did, and it rejected it. Barrett used a pointed analogy. If a prisoner convinces a court that his conviction stands on bad ground, then a little less prison time does not fix the problem. The fitting remedy for a wrongful conviction equals setting that conviction aside, which is what Section 2255 allows. The mismatch between the argument and the remedy signals that compassionate release cannot carry this kind of claim.
And what about the actual innocence argument Fernandez raised as a backup?
Fernandez argued that even if Section 3582 generally can't substitute for Section 2255, actual innocence claims deserve special treatment because no court has ever definitively recognized freestanding actual innocence, meaning innocence without an accompanying constitutional violation, as a ground for habeas relief. If the habeas door stays closed, the argument goes, courts need some other vehicle for these cases.
And the majority said?
2 things. First, factually, no court ever found Fernandez actually innocent. Not even Judge Hellerstein, who granted the compassionate release motion. The judge expressed disquiet and doubt, not a finding of innocence. Second, whether or not Section 2255 covers freestanding innocence claims, a prisoner asserting actual innocence still challenges the validity of his conviction. And that lies close to the core of habeas corpus. Section 3582 provides no shortcut around that conclusion.
6 justices signed on to that, but 2 other justices agreed with the bottom line, affirm, and wrote separately. That's Justice Sotomayor, joined by Justice Kagan. They concurred in the judgment but not the reasoning, and Sotomayor opened her concurrence by calling the majority's reasoning wrong.
What did she propose instead?
A much narrower, more text-based rule. Her argument, the compassionate release statute allows courts to reduce a sentence when extraordinary and compelling reasons arise, and the word arise implies something new, something that developed after sentencing. If a prisoner brings the exact same arguments about witness credibility and trial evidence that courts already considered and rejected at trial, on appeal, and in a Section 2255 motion, nothing changed. The statute's focus on modification of an already imposed sentence requires some post-sentencing development to justify changing the calculus.
So Sotomayor's rule would resolve this case cleanly. Fernandez raised the same arguments repeatedly with no new evidence, without ever touching habeas.
Exactly. And Sotomayor took direct shots at the majority. She called its rule atextual, meaning it finds no support in the statute's text. She called it overbroad, warning it risks shutting out meritorious compassionate release claims just because they faintly resemble a habeas argument. And she called it potentially unworkable because the majority never defined with precision what counts as a collateral attack in the compassionate release context.
So 2 justices agree with the result but think the majority created more problems than it solved.
And then there's Justice Jackson, who disagreed entirely. Her dissent came in 3 layers. Start with text. Section 3582 says, extraordinary and compelling reasons. Those words speak to degree, how unusual, how forceful, not to type. Nothing in the dictionary definition of extraordinary or compelling excludes conviction-related arguments, and Congress proved it knew how to create categorical exclusions. It wrote one explicitly, rehabilitation alone cannot justify compassionate release. Under the legal principle that listing one exclusion implies no others, the majority's judicially invented exclusion lacks authorization.
So Jackson's argument is, Congress built this broad safety valve deliberately, and the majority just sealed it off without Congress's permission. She backed that up with history. Congress designed Section 3582 in 1984 as a deliberate safety valve in the new determinate sentencing system, a system that stripped judges of most of their discretion. Lawmakers worried about federal prisoners who might slip through the cracks and receive unjust sentences despite perfectly conscientious proceedings. Compassionate release preserved a modicum of mercy, and Congress never linked that safety valve to the habeas statute when it created Section 3582 in 1984. And it didn't link them when it expanded the statute in 2018 either.
And Jackson pushed back on Prizer and Gonzalez?
Hard. She distinguished those cases because they involved general civil provisions, Section 1983 and Rule 60B, that bumped up against specific habeas statutes. The logic ran, the specific statute controls the general one. But Section 3582, like Section 2255, specifically authorizes the release of prisoners in defined circumstances. 2 specific overlapping statutes can coexist. No anti-circumvention logic requires one to extinguish the other.
Jackson also raised the actually innocent prisoner hypothetical,
one of the most vivid parts of the dissent. She constructed a hypothetical prisoner, she called him Paul, serving a life sentence for a crime he didn't commit. Paul lacks any colorable constitutional violation. No bad faith Brady issue, no ineffective counsel. The habeas statute provides Paul no avenue for relief. Under the majority's rule, Section 3582 now also provides no relief. Paul sits in prison for life with no mechanism to seek mercy. Jackson argued that outcome defeats the entire safety valve purpose Congress designed into the statute.
What would Jackson have done with this case?
She would have vacated the Second Circuit's ruling and sent it back for the Second Circuit to evaluate, in the first instance, whether the district court's extraordinary and compelling finding actually survived scrutiny on these specific facts, without applying the categorical habeas-based rule.
All right, the holding. The Supreme Court affirmed the Second Circuit 6-3, ruling that Joe Fernandez's compassionate release motion impermissibly challenged the validity of his conviction. That challenge belongs exclusively under Section 2255. Justice Barrett wrote the majority. Justice Sotomayor concurred in the judgment only. Justice Jackson dissented. Now let's get to what this actually means.
So, what actually changes after this decision?
For federal prisoners, this closes a significant door. Any prisoner who exhausted or lost under Section 2255 and hoped to use compassionate release as a second path to raise conviction-related arguments, that option no longer exists. They must run conviction challenges exclusively through Section 2255 with its one-year deadline, its one-shot rule, and its procedural default requirements. And practically, some of those prisoners now have nowhere to go. If Section 2255 already closed on them, deadline passed, second petition blocked, the majority's ruling doesn't hand them a new route.
And that's the sharpest critique from both Sotomayor and Jackson. Jackson's Paul hypothetical captures it. A prisoner with no constitutional violation to allege, no cognizable habeas claim, and now no compassionate release option either.
What did the court leave open?
Two big questions. First, the court explicitly declined to decide whether a freestanding actual innocence claim can ever succeed under Section 2255. The court flagged that question without answering it, signaling future litigation will push on that door. Second, Sotomayor's concurrence invites a different argument in future cases. What if the prisoner can point to genuinely new post-sentencing evidence of innocence? Her changed circumstances rule would potentially allow that. That boundary line will drive litigation.
What about the lower courts now trying to apply the majority's rule?
That's exactly where Jackson's workability criticism bites. The majority draws the line at arguments that collaterally attack the validity of a conviction, but never precisely defined where that line falls. The majority's example of a prisoner citing a chronic mental illness, something the court calls a heartland personal circumstances case, raises the question Jackson posed. What if that prisoner's Section 2255 motion, already raised and lost on the same mental illness? Does the earlier loss bar the Section 3582 claim? The majority didn't answer that.
So district courts will wrestle with exactly where to draw the line between a compassionate release argument and a conviction challenge argument, and the answer may look different judge to judge until the court clarifies it. Bottom line, the Supreme Court told federal prisoners that compassionate release means exactly what it sounds like. Mercy for personal circumstances, not a vehicle for relitigating whether you should have been convicted in the first place.
And if you believe your conviction rested on bad evidence, a lying witness, or withheld information, Section 2255 remains your road, narrow, strict, and unforgiving as it is.
Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn for written rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
And seriously, if you find this valuable, the ratings and reviews make a massive difference. It takes 30 seconds. You can do it before Fernandez finishes his next Section 2255 motion.
Too soon. Talk to you soon.